So your treating doctor requested authorization for some sort of treatment, physical therapy, a referral to a specialist, surgery, something along those lines. Utilization review, on behalf of the adjuster, reviewed that request and denied authorization. If that occurs based on medical necessity, so the utilization review determination comes back and says it's not medically necessary, your primary means of appeal is going to be through IMR. It's independent medical review. If the adjuster denied authorization for that treatment based on some other reason, let's say the left foot isn't accepted and the doctor wanted you to get treatment for your left foot, then you're going to need to address that separately, either by going to a QME, doing something different to get the foot accepted. But if utilization review issues a determination, they do not certify it, so they non-certify or refuse to certify authorization for treatment based on medical necessity, you can do various things. You can write a letter to the adjuster, but it doesn't really do much good. You can have your doctor file an appeal, rarely seems to do much good. You could file a DOR and take it to the board, but the judge doesn't have jurisdiction over the dispute. If utilization review denies authorization based on medical necessity, your means of appeal is to go through IMR, independent medical review. So if you went to the board and said, hey, judge, this isn't fair, the judge would say, file an appeal through IMR. That's what you need to do. So let's walk through the IMR process, how this plays out. When you get that utilization review packet, it's probably going to be 5 pages, 10 pages long. At the very end, probably the last 3 pages or so, there's going to be an application for independent medical review. Put a picture of it up here on the screen. This application for IMR, independent medical review, is going to be almost entirely filled out by the adjuster already. So it already has your information on it, already has the claims adjuster's information, already has your doctor's information, and the treatment that was either denied or modified. Really, the only thing you need to do is sign and date the bottom. There's a time deadline, so don't sit on this. When you get that in, appeal the decision. You have nothing to lose by appealing this. There's no cost to the injured worker to appeal a treatment denial. So you sign and date the bottom of it. You send that to Maximus, and you send a copy to the claims adjuster, and keep a copy for yourself, just in case questions come up later. You have to send that in. Look at the instructions on the form. You send that application for IMR, and you send in a copy of the utilization review denial. That way they know what they're looking for, because Maximus, the company that does the IMR, they're going to make sure that the treatment was denied based on medical necessity. Basically, it's not reasonable and necessary for you to get this treatment. You disagree naturally, and that's why you're filing the appeal. Maximus will get that paperwork from you. They'll look through it, and as long as the denial was on medical necessity, they will assign that to a doctor for independent review. What happens next, you will get a notice of assignment, copy up here on the screen, notice of assignment and request for information. Copy of that goes to you, a copy goes to the adjuster at the insurance company. The adjuster has a duty to send to the Maximus, to the IMR company, all of the medical reports in the last 6 months that are relevant to the treatment dispute. However, you have the right to send in documents as well. So if your doctor requested authorization and it was denied, and then your doctor filed or sent in a letter explaining their rationale, you can send that to Maximus along with the original request. If you saw a QME a year ago and the QME said, Lordy, this guy really needs left knee surgery, and then your doctor requested left knee surgery and it was denied because you haven't had physical therapy yet, but you've already gone through therapy, you can send in a copy of that QME report from a year ago, and you can send proof that you went through physical therapy already as well, and that didn't help. So you can send in documents. Again, there's a time limit. You have to move quickly on this. But you get the notice of assignment, the request for information. You can send in documents to Maximus, and then Maximus will review it. Maximus will then issue a determination. Either they will overturn the UR decision or they will uphold the UR decision. Another copy up here on the screen so you can see what it looks like. Unfortunately, the one here on the screen was an uphold. So utilization review had denied authorization for treatment. I appealed that decision, claiming that it was medically necessary, but Maximus upheld the denial. So be it. We then move on to the next step. That'll be another video in ways to get past that Maximus denial. But this is the issue. When your treatment gets denied based on medical necessity, utilization review says it's not certified, your primary means of appeal is going to be filing with Maximus for independent medical review. Again, all of this, you need to move quickly. There's deadlines. If you sit back and think about it for a month or two, if you say, well, maybe the doctor will write an appeal, maybe the adjuster will change her mind, maybe I don't need to do the appeal, your time may expire and it'll be too late. And then the utilization review, that denial, it lasts for up to a year with the same doctor, the same request. If there's no change in circumstances, that adjuster can rely on that UR denial for a year. So if you think the UR denial is wrong, it's generally in your best interest to file an IMR appeal. If you found this video helpful, hit the like button down below and be sure to subscribe to the channel so you don't miss future videos.